You know, what I'm seeing is a lot of calls from both landlords and tenants. And what's happening is both sides are kind of in a different place. You know, let's go back a little bit. You know, for the last 7 to 10 years, it's been a landlord's market, right? The landlords have run the show and tenants have been clamoring to get into these apartments. Well, near the last quarter or first quarter of 2020, that started to change. And clearly the pendulum has moved now with the coronavirus. And with the laws, the local New York City laws that have been passed, it's very difficult for these landlords to enforce these leases. So what's happening is a lot of landlords are still in this old world, pre-corona, where they're insisting that I'm going to bring a landlord-tenant action against these tenants. Listen, in this new world, everybody's got to be on the same page. And I think it starts with each of us as agents, as lawyers, to kind of go out there and take the high road. Too many people are so quick to look at these documents that were executed and say, what are my rights here? But at the end of the day, the courts are closed. When they open up in June, July, August, there'll be a backlog. And the existing deals, if you think about it, they're going to only be the high profile where there's safety issues. Those will be dealt with first. So it's really up to us to try to get a middle ground. You know, we're consulting with a lot of landlords. And what I've been telling landlords is if you can get 50, 60, 70% of the rent, for April, for March, for months that are going on right now, it makes sense to take it, not to get aggressive with these tenants. It's very hard to enforce their rights. I spoke to a landlord yesterday that owns a bunch of multifamily buildings, and I was able to convince him that if tenants want to leave the lease, even if there's term remaining, it makes more sense to get back your space so you can re-let it to somebody else, even at a lower price in this current market, than fighting a tenant to enforce a lease for someone that may be unemployed and will never be able to pay you. Because what will happen is those tenants will stay there, they'll hold over without paying rent, and the odds are you'll never be able to enforce that. So from a landlord's perspective, it's really take what you can get and really be pragmatic in your approach. On the tenant side, and God knows we're getting a lot of tenant calls, it's a difficult advice. You know, it may make sense in some instances, and David, I'll kind of let you run from here on it, to maybe not pay the rent. And it really, there's a lot of factors, I think, that go into it.
Yeah, thanks, guys. So, I know you guys submitted, there was a list of 14 or 15 really good questions that I want to run into in a few minutes. But real quick, just to echo what Andrew and Alan just said, the typical playbook that we follow with landlord-tenant law is sort of, out the window now, given everything that's going on, and especially all this unprecedented turn of events that's taken place. We can't really just flip over the New York State legislator law and see how we deal with landlord-tenant issues in the corona world. So it's very important for both sides, both landlord and tenant, to have an open line of communication, be as transparent as possible with your plans, try to maintain a level of flexibility and sensitivity towards the other party, try to work something out. If you're a tenant who can't pay the rent, have that conversation with your landlord. Say, hey, I'm not going to be able to make my payments for April or May. Here's what I could give you. Let's work something out. Also, it's very important, if a landlord and tenant do agree to any sort of modification or amendment to a lease, make sure to paper and put it in writing. You don't want to just rely on a text message or email or, just a verbal communication. Don't just assume that the other party understands you to the fullest extent. Make sure to get everything in writing, formalize it, and then both parties can sort of have that meeting of the minds going forward with understanding of how they're going to govern their landlord-tenant relationship. On the regulatory end, there was a bill that was introduced a couple of weeks ago by State Senator Michael Gianaris. The bill has not yet been signed into law, but if it is, it would propose a 90-day rent waiver on both the residential and commercial tenants who have suffered due to the corona situation. It would apply to residential tenants who have lost their job due to the COVID-19 virus, and on the commercial side, it would apply to businesses that have had to shut down due to the epidemic. So there is a lot of talk on the legislation end about relief for renters, not so much so for landlords who are sort of feeling around it. Like Alan said, if you have a landlord that can get something, 50-60% of the rent, it's not worth causing a fight and saying adamantly refuse to take it. Take what you can get right now, and then you deal with the rest later. I know there's a question about the courts. Are they going to open up? What it's going to look like? Housing court, New York City housing court in general, wasn't exactly a model of efficiency. So we can all imagine what it's going to look like once this all passes and courts reopen and they're faced with a flood of litigation, that from the landlord side where they want to get back rent or tenants that have overstayed their lease. There's going to be a lot of issues, and it's impossible for us to sit here today and predict what that's going to look like. Just one more quick
note, kind of what David was just alluding to about, documenting. I think in today's world, unfortunately, we want to get things done quickly. We want, to, make money and get leases, signed up. Just be careful, not to cut corners, right? Clients are your best friends until they're not, right? So it's very easy. Somebody wants an extension, you send a text message or an email or that's done between the landlord and tenant. Just take a step back, take a deep breath and make sure things are done correctly. You're not supposed to draft riders to leases, right? We all know that. All your managers, I'm sure, have expressed that over the last 6 months or so. A lease expires now, it turns into a month-to-month tenancy. A month-to-month tenancy can't be canceled without 30 days notice. And it has to be a full month notice. For example, you'd give notice today for the lease to end the end of May. We all know, in reality, it's not going to end. They're not going to leave then. But the idea is you don't give notice now for the middle of May. You give notice now for a full 30-day calendar month. But the idea there is you don't want to let leases lapse into month-to-month tenancies. You want to create clarity. You don't want ambiguity. You want to lay out the obligations of both parties. Right. So even if it's a simple extension, even if the landlord is reducing rent for this period of time and the tenant has to pay it back, at the end of the lease, or maybe they are, in some situations, and we'll get into it, they are abating, meaning they're, the rent is $5,000, but hey, listen, you pay $2,500 and you don't have to pay back the rest. So it's a negotiation, right? Every situation, every deal is different. But please make sure that you're doing things the right way, speak to your favorite attorney, get some information. Don't start drafting documents. You say, oh no, we're home. Nobody cares. Like, listen, clients, they have no problem coming after you, right? When the dust settles, everybody forgets how desperate they were to get things done. Right. And yes.
Quick question. You said that if a lease expires, it automatically goes to month tenancy. You must have 30 days notice. Do both parties have to give 30 days notice?
No, either party can cancel upon 30 days notice.
Okay, thank you.
David, what's like the downside of letting it run into a month-to-month tenancy versus, doing an actual extension?
Yeah, so I'm always a fan of, not letting a lease lapse and turn into a month-to-month. The reason being is because many times when a lease term expires, landlord and or tenant have additional revisions they want to put into the lease. But under a month-to-month, all the initial clauses of the original lease carry over. So you can't really modify it until you paper a new lease. And of course, we all know that new leases have to abide by a certain time requirement, 30 days, 60 days, 90 days, whatever it may be. So that's why I'm always a fan of just putting them on a totally new lease. And listen, a lot of leases are expiring now and landlords are sort of hesitant to marry themselves to these tenants for another 1 or 2 years. But you don't really, absent a stabilized lease, you don't have to offer a tenant a 1 or 2 year extension now. If we're all just being realistic here, no tenant is going anywhere probably for the next 2-3 months. So you might as well get them on some sort of short-term extension now. We have we've been drafting a lot of such extensions with different opt-out clauses on both the landlord and tenant side. So there are ways to sort of govern this relationship for the short term without committing yourself to a long-term landlord-tenant relationship here.
And just to clarify, in a normal world, what I was saying, 30 days for month to month, to cancel a month to month. Today's world, obviously, everything is extended, right? You can't compel somebody to leave an apartment in today's world, but it's the same idea. Regardless, letting leases just lapse and not having documented information about that it's not the right way to do it. A lot of clients, it's let me be silent, let me avoid, let me not communicate, let me avoid it, let me just play possum. And let's see what happens. We take an opposite approach, right? Communication's key to success, being reasonable. Listen, it's inevitable. Some people use this to their advantage because they really need the help. And some people don't need the help, but will still push and use it to their advantage, right? That's just the way of our world. Go ahead, David.
Maybe we should run through some of those questions that were submitted?
Sure.
Okay. So I'll take it from the top. The first question is, what in your opinion will happen with non-payment cases once the court is open again, given that the court notoriously leans more towards the tenants, even under the best of circumstances? So yes, that's a great point, and we touched on this a bit. Even during normal times, courts are extremely pro-tenant. And a regular non-pay case can take, a month, 2 months before it even gets in front of a judge. It's hard to sit here today and say exactly what the landscape, the court, for housing court is going to look like once this all passes. But if I'm a landlord and I'm just sitting back and, say, hey, you don't want to pay your rent, it's fine, I'll take you to court later. That's a pretty risky strategy.
What about using security deposit, now?
Yes, that's been a common tool for tenants. So, let's use April as an example. A lot of tenants were unable to pay April rent, unfortunately. So they told their landlord, hey, listen, go ahead and take my my deposit for April, and then we'll call it even. So that's, there's no obligation on either side to do that. There's no law that compels the landlord to take the deposit. I don't see why a landlord would not want to do it, if the tenant's offering it in lieu of rent. However, if this does take place, it's very important to make sure that both parties draft some sort of agreement or document outlining this, that they took the deposit. You don't want to be in a situation where the tenant's leaving the apartment in a year or two from now and he's asking for his deposit back because he forgot he used it for rent in April 2020. Also, it's a good idea to have a conversation about how they plan on addressing rent for May, June, July, etc. Once the deposit's gone, that's great and all, but what are they going to do for rent going forward? And lastly, also, as it relates to the deposit, it's also important to have some sort of game plan in mind for how the tenant plans on replenishing that deposit, once all this is lifted and once their monetary situation improves a bit. Number 2, do you think the landlords will get some sort of bailout? It's hard to tell. Like I mentioned a few minutes ago, it's interesting. There's been no legislative action on behalf of the landlords. There's been no bills floated to provide relief for landlords who are losing revenue due to the rent. So it's a good question. As of right now, today, there has been no talk of relief for landlords. If anything, the elected officials are pushing more and more and more towards the tenants. So landlords are going to be in a very, very tough spot. Number 3, are buyers renegotiating signed contracts and how much?
We'll maybe touch on some purchase sale at the end. Well, let me stick with landlord-tenant right now.
All right. Number 4, are the large rental companies like Glenwood insisting on raising rents, or can a tenant negotiate with the large landlords? So tenants, obviously I'm not talking about stabilized tenants whose rent increases are governed by the Rent Guidelines Board. But if you have a regular free market apartment and you're a landlord, during these times is trying to raise the rent, it's definitely, everything's a negotiation. You could definitely push back on that and try to renegotiate. I've seen a lot of landlords renew leases at the current rate. Some landlords have even taken a step further and given discounts if they know that the tenant won't be able to afford even the same rate. So definitely use this as an opportunity to negotiate with your landlord if you are up for a renewal. Number 5, what has to happen if we have a client with a renter whose lease expires on 6/20? Does my owner have to send a personally delivered letter? Please expound. So with leases that expire, at the end of April, May, June, like I said earlier, it's very important to start issuing renewals now. Don't just let the lease lapse. Get ahead of it now. Start drafting the renewal, the riders, etc. If the lease is expiring and you have to give them, there's a certain notice requirement. If the tenant's been in the unit between 1 and 2 years, less than 1 year, it's 30 days notice. If they've been there between 1 and 2 years, it's 60 days. And if they've been in the unit for 2 years or more, 90 days notice is required. Typically, this requirement has to be done via certified letter. However, given the situation, it's probably pretty hard to get a certified letter out these days. So at a minimum, send a regular letter if possible, put something in the mail, maybe send an email with a return receipt requested, something. We want to try to make it as formal as possible. But again, there are limitations now, so maybe just let the tenant know ahead of time that the letter is going to be arriving. Just try to do your best to make sure that it's as formal as possible. All right, next question here. What type of riders are you seeing added to leases post-COVID, and which ones protect the owners versus the tenants? So yeah, this is a good question. So there's been things are starting to pick up now as far as riders and building in different clauses to protect both sides. it really depends on the situation. I have a client now who's asking me to draft a rider. He has a tenant that's supposed to leave in a few weeks and a tenant that's supposed to then take possession a week after that. So we're trying to draft a rider now that protects the incoming tenant from paying rent in the event that he can't take possession of the apartment because a tenant's still in there. On the flip side, you want to draft a rider that makes the current tenant who's still in the apartment continue to pay rent even if they stay over past their lease term. So it really depends on the situation. We're seeing a lot of cases where tenants who sign leases that were supposed to start within the next couple of weeks, they left the city or they can't take possession now, because the building's not allowing move-ins or outs, whatever it may be. It's very important to try to draft amendments to those leases now, so parties aren't left scrambling later on to try to decipher what the lease intended for.
There's a question from Jason. What if someone just signed a lease the week before the pandemic started? Is there anything they can do to renegotiate their rent? We're actually dealing with this as well.
Yeah, so you could definitely renegotiate. Definitely, and I strongly encourage, the tenant to call up the landlord, get them on the phone, try to have a frank conversation with them. That being said, I'm also seeing a lot of cases where tenants paid security or 1 month, plus 1 month's rent, and then they just don't want to take possession of the apartment anymore. They don't want to come to New York, whatever it may be. I have yet to see any landlord return a deposit or first month's rent. And on the flip side, I haven't seen any tenants just pay rent for an apartment that they haven't taken possession with. So definitely use it as an opportunity to speak with the landlord and renegotiate, either renegotiate the rent amount or try to push back the lease start date. There's a lot of different options in trying to straighten everything out. Number 7, has COVID-19 changed real estate forever? I don't know forever, but it definitely had a lasting impact. Andrew, you want to expand on that maybe?
Say that again? Let's finish with the landlord-tenant questions, and then we'll get into some purchase sale.
Okay. Number 8, the press keeps advertising the fact that tenants shouldn't pay rent. See, that's a very good point because, unfortunately, I think we're running into certain situations where you're getting so much press and publicity about the fact that renters aren't paying rent that there are some people out there who have the ability to pay rent, but unfortunately, they feel like they're getting a raw deal by paying rent, so they're afraid to do so. We're seeing a lot of cases where tenants will say, I don't want to pay rent now for April, even though they haven't lost their job, their income is still steady. Hopefully, tenants are not taking advantage of the situation. But yeah, there is a lot of publicity for the tenant side, but not so much relief for the landlord side. Number 10, what recourse does a landlord have specifically in COVID as tenants are breaking leases? Specifically, could a landlord request an amount, in essence, 2 months damages, since mitigating damages by marketing the apartment is very limited right now without moves permitted? So yeah, it's a good question. So on the landlord side, you're really stuck, to be honest. There isn't a lot of legal recourse, for a tenant who just decides to break a lease. Again, I haven't seen the landlord return a deposit in any event where that has happened. So if you're the tenant who plans on breaking a lease, I would assume that's a sunk cost at this point. That being said, try to have a discussion with the landlord. Maybe the landlord will let you sign a surrender or release form from the lease in exchange for 1 month more rent or something like that. Try to have that conversation. The best case would be, instead of just picking up middle of the night and leaving with your lease, in middle of the lease term, maybe try and draft a surrender agreement to have landlord tenant sign off on a surrender agreement whereby the landlord releases the tenant of all obligations under the lease. That would probably be best. What percentage? Skip that one. All right. How can we help in a situation between an owner and a tenant who does not want to start her lease until it's safe to move in? Owner is threatening to sue if she doesn't start paying rent, 415. Yeah, so owner threatening to sue is not exactly doesn't exactly hold that much weight right now because like Andrew and Alan said at the outset, courts are closed right now. There's nothing they can really do. So and it is reasonable for a tenant not to want to move in, either because the building doesn't let, or if they're afraid they're not in the city at all, they don't want to come into the city. It is reasonable for a tenant not to want to do that. So for a landlord to draw that hard line in the sand and say, hey, you're not in by April 15th. April 15th came away. I'm going to sue you now for rent. It's a bit of a silly position. I would, again, just speak to the tenant and say, hey, listen, you want to push off your start date to May or June, and then I won't start charging rent until then. That's probably the best case scenario.
So we actually, Nick, do you want to unmute Dylan. So Dylan Pachulik is here, so he probably has an interesting perspective on all this. I don't know if everybody knows Dylan, but he is a managing agent for single unit condos. So hopefully a lot of you use him. So I'm sure you're dealing with the same perspective, different perspective, so it's great that you're on to give us your thoughts.
Yeah, thank you so much, Andrew and David. It's a very insightful presentation. I'll be very brief because we're going to do a follow-up in a couple of weeks as well through NYRAC. But I can't stress enough the point that Andrew and David are making, which is this is a time to make deals. In normal circumstances, we have the support of the court, and that's really the only thing that entices tenants to pay rent, aside from honesty and integrity as well, assuming you have the ability to pay. But right now it's about making deals. So, if landlord can get at least 50%, take it, because the alternative is not so promising right now.
And it sounds kind of silly for us to say this as attorneys, but you can almost throw the lease away, right? The courts are closed. I mean, it's there in certain situations, but a lot of this is a negotiation, right? You're not running to the courts are closed. Phil asked, is threatening to sue harassment? I don't think it's harassment, but understand that everybody, especially people in Manhattan, we gave a presentation yesterday. Somebody made a good point. Everybody has, not everybody, most people have resources, right? A friend who's an attorney, somebody who can, make a phone call. Threats don't, really intimidate landlords, especially, landlords that have, multiple properties. They have litigators sitting in court, ready to go when the court's open. So, we're putting together, letters, we're reaching out to landlords on behalf of clients, and that'll get attention, making threats, a tenant sending a letter in many situations doesn't get, anybody's attention. And listen, we all know the downside, tenants don't want to, put good money after bad or start hiring attorneys half the time unless, there's a real reason. But that's the way to, get somebody's attention a lot quicker, I guess. Let's see, anything else?
There's a question from June. Landlord wants to start the lease on May 1, but the tenant can't move in because of the COVID. How to handle this? Yes, like we've been saying, have a conversation with the landlord now. Tell them, hey, listen, we're probably not going to be able to take possession May 1. The tenant, understandably so, doesn't want to pay rent for an apartment they can't live in. So let's push back the start date, push back the lease expiration date, just kick everything back a bit, and hope that the landlord is flexible and reasonable in understanding this.
A few other questions that were on the Q&A, I guess, just related to purchase sale. And if you have questions just in general about the market, purchase sale, what we're seeing, certainly type them in the chat box. Are we renegotiating deals? I think now, we're put it this way, we're closing a lot of deals, fortunately, and we haven't renegotiated as many deals as I anticipated we would. We certainly are, a certain percentage, and the percentages are anywhere between 2 and 10%, discount on purchase price. If I'm a seller, I don't entertain a renegotiation unless I know the buyer is ready to close, next week. Why? Because the seller, the buyer can always retrade, right? We have a deal right now. The buyer says, I want to, renegotiate, but I'm not ready to close. The bank's not ready. I said, well, we're not really that strong right now. What are we offering? In my eyes, the incentive for a seller to reduce a price is to get the money now, move on, and not have to deal with the uncertainty that maybe this gets extended past May 15th. Maybe the buyer hires a litigator, tries to negotiate, something, even at a higher level. So if the buyer is ready to close and can close, they definitely have more power. If I was a seller, I wouldn't entertain negotiations unless the buyer is ready to close. I think we will see more negotiations, as people are just kind of sitting tight right now. Understand this, pre-corona, right? 99.9% of deals close, right? They don't get litigated. We do a large amount of volume of deals, and less than 1% of our deals go to court. I think, that percentage may increase a little bit, but, we've been talking to a bunch of different attorneys, and there's word that the courts, might not even entertain these cases right away because they have so much, bigger issues to deal with. They may push everybody to mediation. So people are going to have to work these deals out, right? You can't, I'm sure you've heard by now, you can't snap your fingers as a buyer and get out of a deal. There are no force majeure provisions. A contract's a contract. It's pretty tight, Actually, on the flip side, if you represent a buyer or if you have a deal on contract, let's put it this way, and the buyer's financing, whether it's contingent or not contingent, and they have a commitment, they're ready to close, they should close. Why? If the bank stops lending, that's like, listen, it's a far stretch that banks are going to not fund commitments that they already provided. But what happened? The banks are getting tight, right? The restrictions are getting stricter and stricter. Hopefully nobody else is losing their job, but listen, it could happen, right? What happens if this person loses their job? Then they can't, get the loan. What happens if their assets are further depleted? What happens? I had a horrible situation where a guarantor passed away, right? They're getting gift money. That person passed away. So there's so many intangibles, like there's so many unknowns and variables that if a buyer is getting financing, they need the financing, and they have any, insecurity about their job, assets, anything, they should run to the closing table and not risk, getting that loan in the next 2-3 months. So that's a big, discussion I'm having with clients. They'd love to renegotiate, but listen, they don't have much power right now because the downside is big. And also on the flip side, we use this to our advantage on a purchase recently where we said, listen, we'll close now. We're financing, but we don't really want to close, but we'll close if you reduce the price. So look at your contracts. Definitely. There's provisions in today's world that are applicable, that are highly relevant, that weren't relevant a month ago. So you have to look at your deals. We had, I'm just looking at these questions. June, financing contingent contracts. Should we give longer time? So I had a deal with a colleague where and it's an interesting situation. This would never come to fruition except, unfortunately, in the Corona world. So we actually signed a contract pre-Corona. You should know this. You never think of it, but you should know it. It's a learning tool for everybody. Normal contracts with mortgage contingencies give the buyer typically, let's say, 30 days to get a loan commitment, right? 30 days, 45 days. We usually do 30 days, especially pre-Corona, because we want to keep it tight. We don't want the buyer getting 45 days and all of a sudden they come back to us needing an extension, and then you have to give them another 2 weeks. And your client gets upset, the seller. We want to, push. We want everybody to get things done quickly on the financing end. The contract actually says if the buyer doesn't get a commitment in 30 days, the buyer would normally happen in a pre-Corona world. They go to the seller and say, hey, listen, I need another 2 weeks. Please give me an extension. The seller always gives an extension because then they didn't give the extension, they'd have to give their money, the buyers, their deposit back. What you don't realize is the contract also says the buyer doesn't have to ask for an extension. If they've applied in good faith, they've applied timely, and they don't want to proceed, they can simply ask for their money back. Pre-Corona, nobody would say we want their money back because, they love the apartment. They want the apartment, and they're pushing the bank to, get things done. But we have deals that were signed right before Corona happened. And the first 2 weeks, everybody was kind of at a standstill. Things were frozen. Banks were slowing down. Banks had to, gear up again. So through no fault of the buyer, during the 30-day period, they couldn't get their commitment, and they simply requested to get out of the deal. Now it's kind of, a get-out-of-jail-free card for the buyer, right? Because now the market's obviously down substantially, and they can snap their fingers and get out of the deal, even though they've done everything correctly. So June's question is now that, we're in this, do we need to get more time so this issue doesn't happen again? I'd say, speak to the bank for sure. Listen, if you're on the sales side, it might be hard to speak to the purchaser's lender, but you can speak to, another banker, at that bank. I think the new norm is here, and the banks are adjusting. We're doing virtual appraisals. We're doing, everything is kind of virtual these days. So I don't think, and frankly, the purchase sale business is a lot less than it was, and purchase sale financing deals go to the top of the pile, right? They're handled first before refis. So I think 30 days is still fine, but perhaps you build in some language where if the 30 days expires, the seller can give an extension. The buyer can't, cancel just because the 30 days expires. You don't have to give more time because, again, we want to push the buyers to get things done. Even, pre-Corona or current market, what's the first thing that for you as a broker to think about once the deal's in contract that the buyer's financing, whether you're on the buy side or the sell side? The answer is the appraisal, right? We can't get a commitment, a real commitment without an appraisal. So if you don't get a phone call from a lender, within a day or two after the contract signed, you should be the squeaky wheel. You should be proactive and push and make sure somebody's doing the appraisal. Like, for some banks right now are trying to do actual appraisals, physical appraisals if the apartment's vacant, if they can get access, if the seller's comfortable, and then, go into the virtual if needed. Some banks are just doing virtual right away. So make sure you understand, kind of the playing field for the purchaser's lender. I would, if I were you talking about financing, I would not allow a contingency or financing with a mom and pop bank. I would make sure the banks are getting super tight. There's broker bankers out there. FRB is involved with NYRAC. Obviously a bank like that is a home run in today's world because they're, more based on the relationship with the client. So you want to go to one of the big banks, the Wells Fargo, the Citi, the Citizens, the B of A, the Chase. But Chase, just announced that they're tightening things up. So to have one of these, Long Island small banks or a small broker bank is you just have to be careful, right? You have to see, and you want transparency. Hopefully it's a trusted referral source. And you want, if you have a conversation and say, listen, are you guys lending? What's getting tight, and what's the playing field? I'm just thinking out loud while we have this discussion. It may be smart to, your sponsor contracts. They often say if the buyer, we'll give you a contingency, but if you don't get a commitment with your lender, before we give you your money back, you have to apply to one of two other banks, right? One of the big banks. So I would start thinking about those options. The buyers, we know current contracts, new deals, are getting all the protection in the world. And that's the way you explain it to your clients and you educate them and you flip it and you give them a comfort level. How is a buyer signing a contract in today's world, unless they're buying cash? The answer is they're getting so much protection that it's giving them a comfort level to proceed. One of the questions was, we have full funding language. This means if they don't get a loan for any reason, from contract to closing, they're protected. And then quote unquote Corona language, which says that basically most deals in a normal world close within 90 days if we're financing, from the contract date. But let's say it takes 6 months, 8 months. It's a business decision, essentially a drop dead date. Is it fair? Is it reasonable for a buyer or a seller to be able to cancel a deal if we sign a contract today and don't close for 6 months or 8 months? Doesn't it make sense that, hey, I don't want to be in bed. If we don't close this within 6 to 8 months, maybe there's a bigger issue going on in our world. June asks a question. If a buyer is pre-approved for 90%, should the seller say no? Or do you think the banks, well, the big question, 90% and 80%, in my eyes is very similar. The big question is the appraisal, right? Are we concerned about the appraisal? There are some issues I've seen recently with the drive-by appraisals, properties not appraising, right? That's a concern. So you want to, on one hand, the buyers may insist on an 80% appraisal, but maybe we say, listen, you have the ability to finance 80%, but it's only contingent on 75%. Or if it doesn't appraise, the seller has the ability to make up the difference. I think we're going to see, and that's for you. I know it's hard, there's kind of a separation between church and state with appraisers these days. But if you're the seller's broker, the buyer's broker, and you get some good information over to the appraiser, I don't know how you're doing it these days, but if you can, do it, right? You can't send them cookies anymore, but you can, hopefully send them some comps. But that's a concern, so if you can build in language, giving your seller another at bat if it doesn't appraise, that's important. I imagine most banks are probably staying away from the 90% these days. I don't know if Citi's still doing it, Wells isn't doing it anymore. What else? Any other questions? Purchase, sale questions, rental questions? All right. But, listen, deals are closing, fortunately. Just a quick note about closings. Being a little bit of a hypocrite here, I always encourage, all of you to be super proactive. Top brokers are, pleasantly pushy, push. If you have a deal that's getting ready to close, we think we're ready to close, just, as long as obviously you trust, the attorney and the banker and everybody involved, just take kind of a step back for a second, because it's hard for us to schedule closings unless we know with 100% certainty that everybody is ready to close now. Why? Instead of taking a half hour, an hour to schedule a closing, it's now taking all day or 2 or 3 days. instead of an actual closing being 2 hours, they're 2 days, a day to 2 days. So you can understand that, you know, if we push, then one party's not ready and we thought they were ready, we've just wasted, you know, 2-3 days of work and we have to kind of repeat our efforts. But, you know, just when I was saying be careful with the rental situations, be careful with like virtual walkthroughs, you know, virtual, just, you know, you don't want to send CYAs to your clients, but if you're not there, right, which you shouldn't be there, the doorman or the super is doing the walkthrough, you know, there's only so much you can capture on an iPhone, right? So you want to, you know, I know you hate sending these emails because you don't want to lose the love, but again, clients are your best friends until they're not, right? So just, you know, be careful and say, hey, listen, I wasn't there for the walkthrough. The super did the walkthrough. You know, I know we tested all the major components, but, you know, I wasn't there. You know, you know, clients, again, are your best friends until they're not. You know, 4 months down the line, they start yelling at you for a scratch on the wall. And we all know the walls are as is, but that's the kind of, it's going to happen. It's definitely going to happen. Tara has a question. For any deals in contract which have been negotiated post-COVID, what is the average discount? Oh, renegotiate, I'm sorry, post-COVID. Yeah, it's every situation, every deal is different. Like, and I'm not seeing so many renegotiations right now. I think a lot of my clients are holding off, but I'd say 2% to 10% at most. I had a 10% reduction. That was it was actually a co-op, but I consider it more of a condo because it was a 4-unit co-op downtown, a very lax building. That was actually a month ago. It was one of the first deals we closed. David, any legal issue using security as a settlement on rent?
So there's no legal issue at all. Just make sure that both parties are in agreement that the landlord will take that deposit for rent. Also make sure to paper it. Paper the agreement, make sure you don't want to be in a situation where the tenant's moving out asking for his deposit back and you forgot that he used it for rent. So make sure to put that in writing and, you know, also use this as an opportunity to discuss how rent's going to be paid going forward once the deposit has been used up, and also how the tenant plans on replenishing the deposit down the road.
So just wrapping up, certainly reach out to myself or David, you know, if you have questions, and there will be a lot of rental questions. You know, we are here to be a resource. Anything you need, just let us know. Let me know if you want, you know, you can check out our website. We added a COVID-19 link on our website, which has shareable, for all of you that joined a little bit late, shareable social media, you know, about FAQs for landlord tenant world. So you can, you know, you want to be a resource, right? My goal is to add value for you, so you add value for your clients. So take a look at it. If there's stuff there that you like and you want to share, feel free to do so. You know, let me know if you have questions. One quick question. Andrew, I understand from title company that they were handling closings. Manager, however, attorney is saying the following. Title companies are handling remote notarization only. They are not preparing documents, docs. Yeah, the title companies, first of all, you know, Nick and TitleVest, they've been insanely tremendous and helpful. But correct, a title company does not have the ability to, you know, draft a stock and lease or sign a stock and lease on behalf of the co-op board. What maybe the attorney was alluding to, that maybe they're literally like picking up the documents and bringing them, facilitating the deal. But they don't, you know, you need the original stock book and the lease book. You can't do anything. The managing agent, the title company cannot, you know, create those documents. They're you know, there's no duplicates. I imagine that, you know, we're getting, you know, Nick and his team involved in a lot of not just condo deals where they're insuring title, but even co-op deals where they're just facilitating and, you know, helping kind of things move along. All right. Well, everybody have a great rest of your day, good weekend, and stay in touch, stay strong, keep going.
Brilliant. Andrew, Alan, and team, thank you guys so much for the time today. We really appreciate it. And to the extent there are follow-up questions, feel free to email them to us group, and we'll make sure to push them along to Andrew and his team. Stay safe. Thank you all very much, and we'll talk with you very soon.